This is Barry Zalma on insurance. I am an attorney who is retired from the practice of law and now spend my time as an insurance claims consultant, an insurance claims expert witness, an author and producer of these videos. Today, I'd like to speak about the responses available to insurers to facts that show a potential or an attempt at insurance fraud. Insurers are faced with three major types of insurance fraud. 1, fraud in the inception of a policy of insurance. 2, fraud in the presentation of a claim by the insured. And 3, fraud in the presentation of a claim by a third-party claimant. For there to be fraud in the inception of a policy, it occurs when the insured misrepresents or conceals facts material to the decision of the insurer to insure or not insure the prospective insured. This is a situation where the person seeking insurance deceives the insurer about the risks it is being asked to take. If the insured lies in the application for insurance about a matter that would have, had the truth been known, affected the decision of the insurer may have the right to rescind the policy, determine it never existed, return the premium and deny the claim, or declare the policy void from its inception because of an intentional misrepresentation or concealment. Then there is fraud by the insured in the presentation of the claim. This occurs when an insured lies about a fact material to the decision of the insurer to pay or not pay a claim, or to pay an amount of a claim that is not founded in fact. The insurer faced with a fraudulently presented claim can deny the claim in accordance with the policy provisions or declare the policy void and deny the claim. Finally, there is fraud in the presentation of a claim by a claimant against an insured. In these cases, the third-party claimant makes a false and fraudulent claim against the insured. In all three categories of insurance fraud, the insurer is faced with the same challenges: how to thoroughly investigate fraud and how to prove that the fraud is a valid ground for denying a claim. When a fraud is discovered, the natural response of an insurer is to deny coverage or reject the claim and refuse payment. Various factors must be considered before such a decision is made. Perhaps the most important is determining the grounds for denial and the level of proof that would be required by a judge or jury if the case or claim was taken to court. One of the most often used ground for denying a claim is a misrepresentation or concealment of a material fact. To constitute fraud, an insured must have concealed or misrepresented a fact that is material to the decision of the insurer to accept or reject the policy or to accept or reject a claim. And this misrepresentation or concealment must have occurred with the intention of inducing an insurer to pay a claim it would not otherwise owe. The facts that are deemed to be material for purposes of denying a claim or voiding a policy are unfortunately not clearly defined, and therefore each case must be evaluated separately, and at best with the advice and counsel of an experienced insurance coverage or insurance fraud lawyer. Generally, a fact is material to the application for insurance if it might have influenced a reasonable insurer in deciding whether to accept or reject the risk on the same terms and conditions. Material facts intentionally concealed or misrepresented with intent to mislead the insurer that result in damage to the insurer are fraudulent. Fraud at the option of the insurer allows the insurer to void the policy. A misrepresentation after a loss as to a single material fact will forfeit the entire insurance contract. The insured cannot say, "You caught me. I overvalued my television set, but everything else in my claim is valid." Sorry, you lose. You get nothing if the insurer can prove that that fraudulent act occurred. An insured cannot commit a small fraud any more than he can be just a little bit dead. Once caught in a fraud, the insured cannot demand that he or she be paid the legitimate part of the claim and expect the insurer to forgive the attempted fraud. Insurance fraud is, at least with regard to the relationship between an insured and an insurer, is unforgivable. As the following case demonstrates, however, determining misrepresentation is not always straightforward. In Suggs v. State Farm, a 1987 decision of the 10th Circuit Court of Appeal, an initial investigation by an insurer and the state fire marshal concluded that a residential fire was the result of arson. The fire marshal further concluded it was the insured who set the fire. The insured was arrested and charged with arson. With criminal charges pending, the insured hired experts who concluded that the fire was probably caused by an electrical malfunction. Criminal proceedings were then dismissed. Another expert retained by the insurer later concluded the fire was not of electrical origin, and the insurer denied the insured's fire claim on the ground that the insured had intentionally set the fire. The insured responded by suing for benefits under the contract as well as for the tort of bad faith. A jury found in favor of the insured on both causes of action and punished State Farm. On appeal, the 10th Circuit reversed the bad faith judgment. The termination of the arson prosecution was found to be immaterial because the disposition of criminal cases involved different criteria than civil cases. In any event, substantially conflicting evidence existed regarding the nature of the fire. Based on this conflict, the Suggs court held that the only reasonable conclusion the jury could have reached was that the insurer had not acted in bad faith. The insurer had good reason to believe that the insured Suggs misrepresented facts material to the claim by denying he set the fire. The insurer was unable to convince the jury that the insured lied, but was able to convince the 10th Circuit Court of Appeal that the denial was made in good faith. Although the case resulted in a beneficial or partially beneficial verdict on behalf of the insurer, it reveals the need to deal fairly and in good faith with all insureds, and even more so with insureds suspected of fraud. If the insurer treats the suspected fraud with the utmost of good faith, It will avoid unnecessary litigation, will have sufficient facts to deny a claim, and will explain to the insured all of the reasons for the denial. In some states, like California and New York, when misrepresentations as to material facts are made in an application for insurance, existence of a fraudulent intent to deceive is not essential to confirming the avoidance of a policy. In these states, applying what has been called the Marine Rule, a policy can be rescinded, that is, declared void from its inception, for an innocent misrepresentation or concealment of material fact, as long as the insurer is deceived and acted contrary to what he or she or it would have acted had the true facts been known. In the presentation of a claim, however, the insured's act must have been intended to defraud the insurer, for the contract language relating to voidance of policies because of misrepresentation, concealment, or fraud. Even a gross overvaluation of a claim will not permit an insurer to deny the entire claim or declare the policy void unless the insurer can prove that the overvaluation was not an honest mistake. Courts in different states have difficulty with the concept of fraud and fraudulent intent. The Supreme Court of South Dakota, in a case called Auto Owners versus Hansen in 2000, confirmed that exaggerated claims for the purpose of gaining an advantage in settlement negotiations are considered attempts to defraud, even if the insureds do not expect to ultimately obtain more than their actual loss. On the other hand, that court recognized that there may be an honest misstatement of some fact, and that although as a general rule fraud and false swearing will void the policy, mere mistakes in stating facts that do not in themselves annul its conditions and do not appear to be willful misrepresentations will not defeat the action by the insured against an insurer. It is up to the jury, with instructions from the court, to determine whether the misrepresentation is a mere mistake or an intentional attempt to deceive. The insurer can prove reliance in the application process by showing that it issued a policy based on the insured's fraud that it would not otherwise have issued. In a Massachusetts case, the court found that the insured furnished insurers with a schedule wherein he knowingly exaggerated the sound value of the property in order to be in a more advantageous position to be paid for the real loss suffered, but not with the intent to defraud the insurers. As a result, it held, quote, when it is established that the insured has not only made false statements, even in such a matter as value, for the purpose of influencing the adjustment of the loss, public policy demands that the contract be so construed as to discourage such conduct and to give full protection to the insurer. Materiality of false statements is determined by the result it would have on the insurer, its underwriter, or claims person. Materiality is not determined by whether or not the statements deal with a subject later determined to be unimportant. If, for example, false statements are made about factors other than those that caused a loss, the false statements are nevertheless material. Falsely sworn statements are always material. False statements are material if they might have affected the attitude and action of the insurer. They are equally material if they were calculated to discourage, mislead, or deflect the company's investigation in any area. A fact is material to a claim if it concerns a subject relevant and germane to the insurer's investigation of the claim. Consider the decision of the United States Supreme Court in Claflin versus Commonwealth, which is the subject of another video on the examination under oath, where any misrepresentation of fact made under oath, whether intended to deceive or not, is sufficient grounds to establish the voidance of a policy of insurance and the refusal to pay a claim. The term material means having a natural tendency to influence or be capable of influencing the payment or receipt of money or property. This materiality requirement descends from common law antecedents. The common law could not have conceived of fraud without proof of materiality. This video was adapted from my book, Zelma on Insurance Claims, Part 110, Second Edition, one of a 10-volume work on Zelma on Insurance Claims, available from Amazon.com as both a Kindle book or a paperback. If you found this video to be useful to you or of interest, please forward it to your colleagues. It's free. And please subscribe to my YouTube channel, my Rumble channel, and to my blog so you can learn about future videos and future blog postings. Thank you for your attention.